The rules governing Medicaid long-term care, also called LTC benefits, which pay nursing home care costs for many low or middle-income Americans, vary from state to state in ways that often make no sense. To illustrate my point, I live on Eastern Avenue in Silver Spring. If I were eligible to apply for Medicaid LTC benefits today, under Maryland law, my 401k accounts and various IRAs would count as assets and disqualify me, even if I spent down everything else. If I lived across the street in the District of Columbia, those assets would not count. Is this a sensible way to administer a federally funded program? Of course not. However, if you live in Maryland and are planning for a future Medicaid LTC application, the arbitrary nature of the system will not help you if you apply still holding those retirement accounts. So what can you do? With most assets, the future Medicaid LTC applicant can put them into a properly structured irrevocable trust to protect them from Medicaid as long as two things happen. First, all transfers into a trust occurred more than 5 years before the Medicaid LTC application, and secondly, the trust is administered according to Medicaid regulations. If both of these occur, then the trust will shelter the assets from Medicaid recovery. The reason for the 5-year limitation is the agency administering Medicaid LTC in Maryland will look back 5 years for any transfer into trust and assume it was made to remove a countable asset. Each transfer into the trust would be subject to the 5-year look back, so you want all the assets transferred at once, but the trustee does not have to keep the asset. Only the gift of the asset is irrevocable. The trustee can buy or sell assets as best suits the purpose of the trust. However, the future Medicaid LTC applicant cannot put retirement accounts in trust. A grantor, also referred to as the person who creates a trust, cannot put an IRA or 401k in trust while the grantor is alive. Upon the grantor's death, the account can pass through the grantor's revocable trust and be placed in a see-through trust for the benefit of a Medicaid LTC recipient. However, this is different from the applicant's own IRA or 401k because the income that funded the account was never taxed. Even if the owner of the IRA or 401k is disabled and already has a special needs trust, the only way to put the asset in trust is to liquidate the funds and pay taxes on the proceeds. That is the future Medicaid applicant's only option with 401k or IRA funds. Pay the tax on the funds and transfer them into trust. It might not make good tax sense to liquidate the entire balance at once, so enough can be left in the account to fund distributions that will combine with Social Security benefits to meet the future Medicaid applicant's needs. There is obviously some guesswork involved, but the funds in trust can come to the rescue if the applicant ends up living independently for longer than expected, and the 401k or IRA is exhausted. Here is an important note. You can do Medicaid LTC planning for a loved one, even if they can no longer do it for themselves if they have executed a general durable power of attorney in your favor. In Maryland, the applicant must have initialed the option that allows you, the agent, to make unlimited gifts for estate planning purposes or to qualify the principal for public benefits. It makes eminent sense for a POA agent to also serve as trustee because of the way the trust funds will complement the personal funds as the plan goes into effect. Yet, once that trust is set up, there might be 2 tax returns to file instead of 1. Only with grantor trusts does the grantor continue to pay taxes on income. We do not use grantor trusts in Medicaid LTC planning because the grantor retains too much power to satisfy Medicaid regulations. Finally, do not leave the Medicaid LTC applicant as a beneficiary on your retirement accounts. Not paying attention to details like this could cost your loved one Medicaid LTC benefits that have already started paying. If the Medicaid LTC applicant is the intended beneficiary of your retirement accounts, list the irrevocable trust that you create for their benefit instead of them individually. If you have a revocable trust, first talk to an attorney to make sure the trust is set up to receive retirement account assets. If it is, whatever assets cannot go into your revocable trust directly, such as your IRA, 401k, should list your trust as the beneficiary. Under no circumstances should a person who is or might one day receive needs-based government benefits of any kind be listed as the beneficiary on an IRA or 401k. One caveat to my opening paragraph. The Medicaid LTC applicant is a resident of the state where the nursing home is located, not the state they lived before going to a nursing home. Therefore, a Maryland resident could choose a nursing home in D.C. and keep those 401ks and IRAs so they remain as a resource. However, there are considerably fewer beds in the district and the facilities available might not be suitable to the applicant and their family, for example, because of location. In addition, just because an asset is not counted during the application process does not mean that the state cannot recover against the asset when the applicant passes away. Venue shopping for Medicaid LTC can provide a benefit for some applicants, but it can also turn into a case of the tail wagging the dog. In conclusion, Medicaid LTC planning is a complicated endeavor, and all the more so when retirement accounts are involved. I am licensed in both Maryland and the District of Columbia and familiar with the rules in both jurisdictions. If you think you or a loved one will need help paying for a nursing home in several years, come talk to me. You cannot be too early, but you can be too late.